Thank you for participating in the NIA and NHLBI Entrepreneur Workshop Series. This workshop covers the topic of intellectual property. This breakout room, moderated by Gautam Prakash, discusses the topic of elements of a patent application.
Welcome all. I'm happy to be here, happy that you've all come. So I'll give you my disclaimer again. This is not meant to be legal advice, so I'm happy to answer any questions that I can. And if it's getting to a point where I think that you need professional help, because this is a complicated process, I'm not expecting anybody to become an expert after this, I will say so. So what I will do now actually is I will start with seeing if anybody has any initial questions, because I already have a bunch here, but if anybody who's signed on right now has any that we can start with, I'm happy to do that because you're all here and I'd like to give you an opportunity to do that. So I'll just take a minute. Okay, but hearing none, I will go to the questions that I've already been asked. Here we go. What part of a software is secret source? So, everyone, I'm not quite sure what you mean by that. Maybe
sauce.
Secret sauce. Sorry,
the secret sauce.
Yeah.
There's the process, and then there is the outcome of what an app intervention, a medical app might do. Mm-hmm. And so, where are those lines between what we apply for? I think there's something called a process patent I heard about. So how do you divide this? Okay, so actually, if you think about, at least the way the patent office thinks about software is that it is described as a process, right? So the way you would what you want to do is you want to write a claim. So this is the most important part of how you describe it. The claim would be what steps you want to protect, and the result would be what you're trying to achieve, and the result would be written into the specification or the detailed description. So the idea being what you're actually going for, what you're claiming, is a series of steps. Yeah, so that's your process. So when you ask about a process patent, really that's another term for a patent that has method or process step claims. So you don't claim the software. What you really claim, in other words, you don't claim the code. What you're claiming is a series of steps that does what the code does. And then in the text of the patent application, you'll be putting in all the various things that you think that this code will do, the software will do. And you need to describe it in sufficient ways. How do you describe it? How much do you put in there? Well, you need to put enough to describe, and the word that we use is enable the steps that you're claiming, right? So if you're and the result that you're claiming. So if you have enough in there, so I'll give you an example of one that I see all the time. A processor for turning some kind of switch, right? Or I don't know, let's say it's a device and it's doing something. And in the specification, the applicant has put nothing in there about how this processor works. Nothing, other than just saying, I've used a processor. Well, hooray for you, but that's not what I want to see, right? So if I'm looking at this application, I'm looking at the claims. You're claiming that this processor is going to do these 7 steps in this order to get this result. What I'd like to see in the specification is what are those steps and how are you going to get that result? Okay, so the algorithm and the series of steps of how you're going to do that. That's what I need to see. You can't just say I'm claiming a processor to do a certain feature and not tell me how the feature is. The problem there is we have what is known as a lack of written description, and you can have a lack of enablement. So enablement basically means somebody of skill in the art looking at what you have written cannot figure out how you did it. Right, so that's your goal, is to show enough. And where's the line? I don't know. Please don't ask me because it always changes. But you have to show enough
such that people can figure out how to make and use the invention they're claiming. Okay? Hopefully that is something of a help. I see another question in here from, is it from Christian? Thank you for that. What is the current state of play regarding utility patents, predictive algorithms? Okay, so algorithms themselves are not patentable. So predictive, so if it's just written as an algorithm, you can't claim that. And but is there something more that you had in mind, Christian, about the algorithm itself? If you please unmute yourself, I'd love to hear it.
Hi, so it's really about a predictive model we're building that is related to a particular chronic disease, and it provides predictive insight for the caregiving givers of these people with this particular chronic disease.
So is your question, okay, so if again, a lot depends on how you're claiming it. If you're claiming just a series of mental steps that say, I, look at a patient, I figure out that he or she needs something, right? I predict that he or she might need something, and I go ahead and give some treatment based on that prediction. Those mental steps or that method of doing is not going to be patentable, but doesn't mean that there's nothing there. And that's why when people hear, oh, algorithms are not patentable, I'm not even going to start. As is always the case, that's not the be all and end all of anything. It really looks on how you plan to use an algorithm that's incorporated into a real world use. And it looks like you have one there. May be patentable, again, depending on how you write the claim and how much of the universe you are claiming. So a question came in earlier, and it may be appropriate for your, maybe you asked a question as far I know, is, how do you, I'm sorry, give me a minute. The question was much better phrased than I can do it. So let me see, it was well done. Okay, so it related to what types of technologies have issues with Section 101. So for those of you who don't know, Section 101, as John Darling pointed out, involves what actually is patentable. So Christian, your question goes to that. That line has changed. When I first started, just like with John, we never asked those questions. If it was written a claim, it was good enough. We didn't make 101 type rejections. But now we do a lot of those. So it has come to be told to us by the Supreme Court and other courts that algorithms never patentable, methods of doing business not patentable, mental processes are not patentable, anything that's a product of nature not patentable. So where this line is constantly shifting. But to your question, the pure naked algorithm not patentable, but incorporated into a device or a process, depending on how it's claimed, might be patentable. So Christian, I'm sorry I don't have a straight answer for you, but that's the best I can do, and I hope it at least helps for you to think about how to do. In other ways, what is the narrower you claim and the more real world your application is, the better off you are. If it looks like you're fishing and you are trying to get a broad slice of what is not either you haven't invented or trying to block off other people, that's when you start getting into trouble.
Got it. Thank you. So one last little bit here is part of this is that this is going to be based on a stream of data that's real time and stream of data that's been built up over a period of time that's related to that particular patient. So does that help things?
So again, so you're going to collect data from particular patients. You're going to analyze those data, and then you're going to predict a potential treatment. Is that accurate?
The predictive part is based more on being able to flag adverse events before they occur.
Mm-hmm. Yeah. So I mean, Again, in theory, sure, there's always something there, right? If your claim is much broader and you could predict any kind of if it's more trending into what a doctor would do in their normal course of business, and you're trying to kind of algorithmize that, you're gonna run into trouble. But if there's something a little more specific there, maybe. I can't tell. So.
Okay.
Mr. Kennedy, thank you for your question. I see your hand is up. If you want to unmute yourself.
Yeah, hey, this is Jay. So quick question about, so if you search my name on the patent website, my name's probably in about 50 patents because I made a comment on adenovirus back in the 90s, and people use that as an example of, if you want to express a protein in the context of an adenovirus, right? That paragraph is copied verbatim across like 50 of those different applications. So in academics, we would call that plagiarism. But apparently in patent law, that's not a thing. I mean, can you kind of explain that? Because I've seen this come up, in the setting of academia, that the rules for patent writing are pretty different from, rules of traditional scientific writing.
Yes. So we wouldn't the reason we don't call that plagiarism, even though if they've lifted the paragraph right out of your, a paper of yours or even one of your earlier patent applications, is presumably they're using that to describe the prior art. That'd be right, Chase. So they're not saying I invented it. What they're saying is this is known. So you may want to see, instead of plagiarism, I would contribution to this earth, right? So, and that's a good thing. So what we try to do, and this is one of the things I would strongly recommend to people who are writing patents, is, you want to put your idea and your invention in the context of what's already out there. So in this particular case, I'm saying, I'm Gautam Prakash. This is not me. Jay Kennedy has already done this, yeah? And I'm building off of what he has already done or created. So it's more of an acknowledgement of your contribution rather than I'm stealing his idea, right? And the concept again is the reason why we issue patents and the reason why we want to do this sort of limited monopoly and we give people rights, which seem kind of unfair, is we want people to disclose and we want people to build on what has already been out there. So, so this would be I'm building off Jay Kennedy's building block, and I'm going to move on. So I need to acknowledge him, right? Because I don't want anybody to think that it's my thing, and it's not my thing, it's Jay Kennedy's thing. So if you're in 50 different patent applications, I take that as a plus. So for what it's worth.
Thanks for that clarification.
Yeah. Okay, I will, thank you for those questions, they're wonderful. Anybody else who's live, I'm happy to answer those questions because you're live and you're here. If not, I will go to some of the ones that have already been asked of me. So again, I'll just give people a minute. There's no urgency to ask me if you have any questions live. Okay, so let's then I'll go to the claims lost because they're actually very, very important. And I'll dispense with a couple of other things else quickly. Drawings. Do you need drawings? Should you have drawings? Listen, if you're doing a device, as I said in my introduction, you should have good drawings. They're easy to draft. There are draftspeople who can do it really nicely. And it is invaluable in helping understand a device. So different views, if you're making a heart monitor, a heart valve, a stent, all these things are devices, they need drawings. What else can be considered a drawing? Gels, other kinds of graphs, all those are fine. The data, you need to decide if you really need it. If you need it, put it in there. Sometimes a table will suffice, other times you'd like to have a graph. Those are all perfectly fine to have as drawings. So before anybody have any questions about drawings? If not, I will move on to the specification, which is the second most important piece of patent application. Elron, did I see your hand up?
Yeah, so part of what I'm trying to develop, I I suppose would be considered like Christian was talking about, a predictive algorithm for which action can then be taken by a caregiver. I suspect Christian and I are in completely different ways using these words in terms of the content. And I guess the question is the relationship between the databases in the building of the app. You know, there are maps. There's like, well, if we know this and we know that, and we give this 20% weight and that 80% weight, this is what we predict. Should that be described in a narrative, or is that better described, like, if you will, in pictures, in a schematic of how it's working?
Yeah, yeah. So I've seen it both ways. I would never use, and you can't use a schematic without some descriptor of it in the body of the application, right? So if you want to show a series of databases, lines connecting all of them, weights, and so on, that's shown nicely as a schematic, absolutely. Or even a set of logical steps going in an algorithm, do this, then that, if, then, so on. But certainly I would back that up with text in the specification to say, with respect to figure two describes a mechanism of querying a database to provide some information, and then go through and just have a nice bit of paragraph, or maybe longer, on that. So typically what ends up happening is you'll draw or you'll create the figures, and then you will have a paragraph or two on each one and build that into the narrative such that they all sort of fit together. And you want this to be sort of, at the end, you want to tell a nice story of what has come before, right? What the J. Kennedys of the world have invented or described, how you are building on it, and how your building makes a difference to what it is. I've seen a lot of things where they just throw a lot of stuff out there, and I read and I can't figure out what is actually new here. That's not the way you want to do it. So, but how you choose to tell your story is entirely up to you. The better that you can tell it, and the more interactive, if you want to say that, not interactive, interconnective the various pieces can be. The claim should match the drawing, should match, they should all have a sort of common theme to it. That makes for a good story. So I wouldn't say that it's exclusively one over the other. They should all be sort of complementary, if that would be a good word to use. Okay. So that actually takes me very well to the specification. Right. I have seen a lot of us scientists write specifications that look like preprints of an abstract. Preprints of a paper that's going in. Right, the galleys before they get submitted to, in my day, it used to be like they sent off to the publisher, but now it's just put on a website. That becomes the specification and the detailed description. I do not recommend writing it like that. In fact, whenever I see something like that, it's horrid. So what I'd like to say is, actually, there's a great question here came in from Mrs. Brar. We let our patent attorneys draft the patent and claims and review. We're hands off. Is a good strategy. Yeah, hands off in the sense that what I would say is you should read it and see if it matches what you actually think that you should. A patent attorney, such as John Darling, what he would do is he will take what you've given them, like the preprint of the abstract, write it in more, write the story better, hopefully, and take out unnecessary materials and methods. Do I really need to know that you did a NMR and DMSO? Of course not. I don't really care about that. But write it properly. Put in the data that is necessary to, once again, to provide written description and enable, meaning make and use what you're claiming. And what a patent attorney will do is they will talk to you and say, okay, look, we said 100 degrees. Could it work at 120? Or we said, that the protein has to be this size. Could it be a little bit bigger? So try and sort of broaden it out a little bit, not beyond what you have invented, but offer you the opportunity to say, is this invention just specifically what you have, which is fine because it wouldn't work in a different way, or could it be modified slightly and still work? Those are the kinds of things. So I wouldn't say, here's my preprint, write the specification. I don't want to see it. What you should do is you should get it back, see if it's technically correct, because if it's not, then you're in trouble. But more than that, if it's technically correct, start seeing where you can sort of open it up a little bit, right? Because we're all scientists. When we do our experiments, we do it at 50 degrees. We don't think about doing it at 55 because that's not what we care about. But it's the patent attorney's job, or should be, let's say, a good one, to ask you, because they should have enough scientific knowledge, ask you whether subtle and minor variations will still make the process or device work. And the answer is yes, then you want to either claim or at least describe those. Why? Because you don't want somebody to go around what you've got by making obvious and minor variations. Major variations, well, that's fine. That's what the patent system is created for. But minor variations, you want it to sort of be within what you have contemplated as what your invention is. So it's important to have good claims. And this is maybe a good segue into the claims. Everybody says, oh, I got really broad claims. Claims are really broad. It's so great. That's a double-edged sword. Because the problem with the broad claim is that the broader the claim, it's very likely that that some other thing is going to knock it down. Some other piece of information, or what we call prior art, that's out there that's going to invalidate a piece of your claim. Now, when we're in court, if there's a piece of prior art that invalidates a piece of your claim, the whole claim is out. At the patent office, you can kind of chop it down a little bit and kind of neaten out the edges. But once you're in court, of course, I don't have time for all that. Once a claim is issued, it's presumed valid. If you can find a way to invalidate it, it's gone. Okay. Another way you can invalidate claims is showing that you haven't invented the entire scope of the claim. I've got this huge, broad claim, for example, and it's a preposterous example, so please bear with me. I have a new compound. I say it treats cancer. Okay. Now, of course, treating is its own thing, but at one point, maybe that would have been okay. But now we realize that there are so many different forms of cancer. And even in a certain type of cancer, there are many variants of that cancer. So if you say it treats all kinds of, let's say, pancreatic cancer, and then there's one that it doesn't treat, well, you've claimed more than you've shown, right? So broad claims, they have to be properly broad rather than just universally broad, because the broader they are, you're going to run into other problems. You also don't want to have too narrow claims as exclusively. You want to have a good set of claims, narrow enough that cover your commercial embodiment as best as you can think about it while you are drafting the application. So what does that mean? I always recommend to people, when you're writing your patent application, think about what your commercial embodiment is likely to be. It's predictive, of course, because that's in the future, but think about what it's likely to be. And if you can envision what that would be, everything follows from that. The specification, the title, the drawings, certainly the claims. So if you can envision what your commercial embodiment or embodiments are likely to be, then claim those. Write the specification around those and broaden it out a little, because you always want some flex in the system. But if you start with that as your guide star, you're going to be much better off than saying, I've got this general idea, which idea is not patentable anyway. I've got this general idea and it could do a whole bunch of different things. Well, that's great, but always better to focus on the specifics and broaden out rather than going from a broad to a narrow. So hopefully that helps you when you're thinking about either writing the applications yourself or, as Ms. Brower says, I hope I'm pronouncing your name right, please use that to tell your attorney, look, that's not mine, right? Or that is mine, or it could be mine. That's the kind of thing I'm thinking about. So I hope that answers the question.
So we had a situation where we filed a patent and for composition of matter for our drugs. And we wanted just to prevent any derivatives from that drug, the sequences, etc. We had like 85%. It can't be more than sort of, we had an 85% threshold in similarity. And it came back and then we've got to make it more specific, right? So we've now we were broad first, and then now we've got to go back to narrower sort of claims, more specific to our sequence. Once the search has been done, there are some sequences out there. So we're like 90% for one drug. And so, you know, you learn as you go along. You know, we didn't do the searches originally, but when they're coming back from the patent office, you know, that's sort of then refined our claims. So we just start.
So that's exactly. Yeah.
That was not our knowledge. You know, our knowledge originally was, oh yeah, we're covered, you know. But then once the search comes back, you realize you're not covered, then you have to then, you know, make them say 100% sequence identity to one, you know.
Right. Yeah, that's a great real world story of where, you know, having too broad claims, not helpful, because you don't want to go through thinking you've got coverage when you, or protection, should I say, when you don't. So it's a fantastic lead. And I swear I didn't ask her to put this statement. It was a fantastic lead. And Ms. Brow, thank you for my next point, which would be, should you do a search in advance or not? Do you have to? No. The patent system does not require you to do a search of the prior art or what's already out there. It does, however, require you to disclose what you know. So I presume Dr. Brow is an expert, so she is going to know about certain things. She's going to talk about it. And she's got to disclose to the patent office what is relevant to the patentability of what she's claiming. Great. Do you have to go beyond that? No. But as she correctly found out, it's worth doing a search. If this is important, it's worth doing a search of what's already out there. And you, like, the question I'm always asked is, where do I look? You're an expert. You know where to look. You probably know the field. You know what's out there. Not to say that the patent office will not find something else that you didn't think of. Obviously, well, that's the job of an examiner, to go do a search and do these things. So, and they're better at it than you are. That's not your day job. So I fully understand that you think, oh my God, I can't believe I didn't find that. Not to worry. But what I will say is that the more knowledgeable you are on what's out there, the more likely it is that you can tell a better story and get the claims and understand what your advancement is over what's already out there, and get claims that reflect that advantage or advancement, sorry. So you're better off doing that than just sort of walking in like, you know, I don't know, I don't want to know, just tell me. Well, that's that iterative process of saying, I'm claiming this much, and the patent office says, well, you need less. No, I can find something here. I mean, it takes a lot of time. So here is one of these things where I was in high school. Our school motto was knowledge is power. And I really do believe it in this case. The more you know, the better off you are on getting better claims. And I had a question come in about how do you avoid trolls and so on. There's no way to avoid a troll, but the stronger and narrower your claims are to some extent, the less likely it is that they can troll you with trying to get those claims knocked out, right? So broader claims, probably easier to knock out, narrow claims, less so. So it's good to have not claims that you can get through the office. You want to have patent claims that you can enforce. That's the game, right? You need to have claims that provide the protection that you want, and then actually when somebody comes after you, you can enforce them. So there's no algorithm to get there. A lot of it, as she correctly pointed out, is trial and error. The more you know, and knowledge gets you to hopefully where you want to go. So a great question, thank you. So we have another about 10 minutes, and anybody else on the line have any questions? Aaron, again, did I see your hand?
There we go. I don't want to hog the space, but if people don't have questions, I definitely have questions. So I went through Trademark because I didn't want to be building a brand under my company without knowing that, you know, I had the license, the registered trademark. When it comes to the trademark, as soon as your application goes in, you basically have a provisional right to that, right? Because you can do a trademark prior to the R. So you can you're claiming publicly, and the trademark office says that, if once we go through the process, it basically dates back to your application date. Does that happen in the patent side of the office as well? Because that's what I think the impetus to go broader while you're still in research and development is to protect the space for what will be a more narrow claim.
Sure. So I'll answer the first question first. So the way the trademark rights come from use, patent rights don't come from use, right? You could get a patent and not ever license the invention. It can just sit there until the patent expires and off it goes into the public domain. That is not the trademark. In fact, trademarks go abandoned if they're not used. So conceptually, they come from different sort of ideas, okay? So that's the reason why you can use something and have a trademark and have that, the rights go back to the use rather than when it's registered, okay? Patent's different. You don't want to disclose something before you file the application. So generally, patent rights come from filing rather than prior use. Generally, there's a little bit of a nuance there, but let's go with that. You're safer going with filing rather than invention. But you really want to get into the habit of filing first. But you are right. You should write initially broad claims and broad concepts. When they come to getting issued and you look at the patent office's search, you look at what's already out there, then you can start narrowing it down accordingly. So it's one of those things where you can decide how you want to play that, but certainly you want to think broadly, but you want claims that are narrower than I'm taking all the universe that there is, right? So that's kind of where that comes from.
Okay.
So yeah, I have a note that we're about 5 minutes out, so I'm going to answer this question again from Ms. Brower. Thank you. Here's the question. I'll read it out. A patent attorney for therapeutics says it's better in certain situations to increase the patent not to delay issue. So that used to be one of the old strategies for getting longer patent term, because it used to come from the patent term was calculated from the issue date, not the filing date. So now, there used to be a lot of what we know as submarine patents, where the patents would be like lurking around, they constantly delay issue, and then when a technology came up, they would get issued and cause all kinds of grief. So 1993, I believe, so it's been a good bit now, they changed that to the patent term goes from the filing date. Now the question is which filing date, that there's international filing date, there are domestic filing dates, but let's just say it's 20 years from the filing date. And so not the provisional filing date, but from the patent application filing date. So in some ways there is less incentive, if I might even argue no incentive not to issue something, because you can't enforce something. You can't enforce a patent that hasn't been issued. I can't walk around saying, you see this thing that I have here? I don't see anything. Well, the thing that I could have here if I got it issued, I want to sue on that. You can't do that. So it really depends on what it is that you're going after. You could file, what John Darling was referring to as continuation or other types of patents based on the parent to protect other aspects of the invention, but delaying, and you may want to sort of delay the issue until you file those, and it's not even delay, it's more like don't pay the issue fee right away, just get those things filed before you pay the issue fee. But I wouldn't necessarily say that delaying the actual issue of a patent would be as a very promising strategy. So unless there's something specific here that I'm missing, Ms. Brown, correct me if I'm wrong on this, but I wouldn't, please elucidate me, but in and of its strategy of itself, I would say no.
Is patent pending restricted? Okay, so Elron again. Is patent pending restricted, regulated, those who've actually filed? So do you mean, can I say patent pending if I have a, if I don't have a patent application pending? Is that what it is?
Yeah.
Yeah.
I mean, it shows up on so many products.
Yes. So that
are they real patent pendings?
I would say yes. You would be asking for trouble, I think, if you say something's patent. Now, will it ever issue? I don't know. A lot of patents don't issue, but I suspect that if they say there's a patent pending, it could be on some aspect. Now, could it be the whole thing? It's a piece of it. Who knows? But I would, maybe it's a hope, but I would hope that if it's a, if you put the words patent pending on there, that it's not just, back to your trademark thing, not in trademark terms called puffery, which is like, you know, you say the world's greatest hamburger. How could they possibly know it's the world's greatest hamburger? Of course not, right? But that's allowed because it's part of advertising and so on. But patent pending is I think, a little more serious than that.
Okay.
So yes, I would say more often than not, and I have no data to back it up, so don't hold me to it, but I would say more often than not, there's some aspect of it that probably is under, that they're seeking some patent protection for.
Okay.
So it's 4 o'clock now. Please don't feel obligated to stick around. I'm happy to stay for a few more minutes. I think we have the Zoom link going for a little while longer. So if those are questions, I'm happy to stay. Those who would like to leave, welcome to. You don't have to go back to the main room. You can if you want to, or you're just welcome to leave right now, or please stay and if you have any more questions.
Yeah, and just a reminder to fill out those feedback forms. We really need to know how we should make these the best for you. And also a great thank you. It's awesome to have someone, you know, from the USPTO that has that expertise here providing guidance to each of you. So thank you so much, Gautam.
Well, thank you. And so for those of you who don't know, this is Dr. Todd Heim. It is through his auspices that we have this thing going. So thank you for putting it on. Great idea. Plus also, you know, doing all the background work on it. We really appreciate it.
I have a question. Would this recording be made available to my colleagues, those who couldn't join?
Yeah,
I think
I'll leave that to you.
very important, I would say, workshop. Very important.
yes. This meeting is being recorded and it will be available on the NIA SBIR events archive page. We do need to make it, you know, we want to make it 508 compliant and stuff. So that does take time so that everybody can access it. So typically it could take a couple weeks. But once that is done and it's in a format that everybody can access, it will end up on our website.
Okay, thanks, Todd.
Probably NHLBI as well.
Thanks. Great ideas. Could have taken half a day with all the questions.
Oh yes, that was the issue, and we had discussed with Todd before. One of these topics can take a whole seminar. So,
right.
But thank you, Mr. Butt. This is exactly why we need your feedback, and we want to tell the NIH, the NIA, the Heart, Lung, and Blood Institute that these are interesting topics, and we can see what we can do to help out.
I think there should be more meetings like this.
Todd, I'll leave that to you as well.
We have a series of, I think, 11 of them. So, you know, we encourage you. I think this is number 3, well, so there's 8 more.
I somehow or other, I didn't get any announcement, and I got it around 1 o'clock. So I said, hey, that's good.
Well, you now will get the, well, once you attend one of these, you'll get the announcements for the future ones. So,
okay, great.
Yeah. And you have the link. It's on our website. So you have the direct link from the slides, which you'll get.
Okay, thanks very much.
Could be a mixed blessing.
So I have a family question, meaning that my son is in product design. He came up with this idea for a chair. Of course, the chair is ubiquitous. He hired a lawyer who I happen to know from 30 years ago. It's not clear that he got from her enough direction because the patent was denied. My experience, at least on the trademark side, is that you get, I mean, my trademark came through without a denial and without any objections, even though I had done a lot of research ahead of time and all of that. But the response from the lawyer was that the claim, I guess, was too broad, or the description, the specifications weren't narrow enough. But he's telling me, and since I'm funding his development, he said that he didn't get any guidance from the office about kind of what was wrong with it. Is that typical to not get guidance?
Not at all. Not at all. A patent examiner cannot reject a claim for anything without providing reasons why what is claimed is either known or obvious in view of what's known. So those, and they're all part of the public record, right? So, and it's important, right? I can't reject something because I do or I don't like Todd Hein, right? I happen to like him, so I'm going to give him a patent, right? I can't do that. So I have to examine his claim on the merits and make it clear what aspects of the claim are patentable or not. So this is what we call an office action that we receive from the United States Patent and Trademark Office. It should list very clearly why what your son is claiming, or whatever the device is, it doesn't matter, whatever the claim is, is not patentable for these reasons. And as a result, you can overcome those reasons by either amending the claim to make it narrower, to get rid of those things, or argue against them. They're both equally valid options, and sometimes a combination of both. So I'm claiming what's already in the prior art. Okay, I'll slice it down to what's not in the prior art, plus I'll argue why it's not obvious in view of what's already out there. Or the examiner could just get it wrong. I've seen situations where, and I myself, the applicant I thought it was taught in the prior art, and the applicant has said to me, no, what you think is that, A is actually B. Oh, okay. I find that persuasive, or not, depending on the situation. So yes, we cannot, it's unlikely, no, it's not, it's impossible for the patent office to accept or deny a claim without any kind of written record as to why. Those days are gone. In the old days, it just used to say, claims, denied, go look at this patent. Thank you very much. Now you have to put chapter and verse on why and where in the prior art that knowledge can be found.
Okay, so he should be able to access that on the U.S. Patent and Trade Office website. Correct.
Yes, if it's been published, that information is public, and he has his patent application serial number. The system is called PAIR, P-A-I-R, Patent Application Information Retrieval, I think is what it's called, what it stands for. And so if you go to the public version of PAIR within the Patent Office's website, you should be able to find it somehow. The Patent Office's website isn't the best, frankly, but you should be able to find it. There you can type in the serial number and the patent application serial number, and it should have a nice record of the whole sequence of events. When the application was filed, what the rejections were, what the response was, where this application is in the patent prosecution process.
Right. So then, as somebody now in my position looking for an attorney, like other things in life, past experience is no guarantee of future success. What would you recommend about finding a lawyer, and how early in the process of our invention or innovation should we be contacting a lawyer, and what can we expect that they will do? Because I said, well, didn't she give you guidance about what to write? And it's like, no, she told me you need to write a description. I wrote a description. So, he didn't study like the 8 million examples of chairs out there about why his was different. So I'm just wondering where that division comes in when it comes to me and, you know, what I'm trying to innovate, which I hope will be with the NIA's help, but I didn't fare so well in the last round of applications. So we'll see what happens.
Yeah. So sadly, it all comes down to money. And, you know, the earlier you can engage a competent attorney, and the Patent Office has a list of registered patent attorneys and agents, the better you are, because a lot of this, you know, you want the earliest priority date that you can get. And you want your application to be as complete as possible from the beginning, because you're not in a position to add stuff later on. So I will say there's no, you know, again, I'm not independently wealthy, so I can't just say, oh, you know, go get yourself an attorney from day one. We all have to work with the resources that we have. But if I had a choice and I had the resources, I would hire people early, hire attorneys early. The process is complicated. Actually, it's not that complicated, but it's not your job. You've got other things to do, right? Mm-hmm. So, you know, the sooner you can get somebody to write a better application, write better claims, navigate the process for you, respond to, the better off you are. So that, sadly, that's my best advice, which is the earlier you can get, you may be able to avoid some of the pitfalls. And when you're talking about a well-known device, I mean, it's going to be harder, just for a fact, right? So let's go back to the medical area. If I'm going to try and patent a catheter, you know, 50,000 catheter patents out there, for example, maybe 100,000, I don't know. You know, you're going to have to, it's going to be narrow, and you're going to have to know what's already out there to make a claim why yours is better, different, whatever. So that's when you really need somebody who understands the area, that's the scientific piece, but understands the process as well.
Mm-hmm. Okay, thank you.
So I think we need to wrap it up, but thank you all for all the questions and for participating. And thank you, Todd, and the rest of the NIA and Ogilvy for hosting this. I really appreciate it. Great job. Thank you.
Thank you.
Thank you.